In 2017, Police Inspector Kamta Prasad Mishra was caught in an anti-corruption trap case. When the state government finally granted sanction to prosecute him 3 years later, Mishra filed a right to information request. He wanted to see the exact decision-making process that led to his prosecution. The Madhya Pradesh Special Police Establishment, the very agency that investigated him, denied his request outright. Initially, the state argued that releasing these documents would impede an ongoing investigation, citing Section 81H of the RTI Act. But the investigation was actually already complete, and a charge sheet had been filed. The state needed a stronger shield. That shield came in the form of a 2011 notification issued by the state's General Administration Department. This document looks at Section 24, subsection 4 of the RTI Act, which allows state governments to exempt certain intelligence and security organizations from transparency laws. The 2011 notification used this exact provision to unilaterally classify the special police establishment as an exempt entity. This specific refusal poses a serious administrative law question. Can a state government simply declare its own domestic anti-corruption police force immune to federal transparency mandates? To answer that, we have to look at the legal hierarchy. At the top sits the Constitution. Below that are plenary acts passed by the legislature. At the bottom is subordinate or delegated legislation, the specific rules and notifications created by the executive branch to implement those acts. The Right to Information Act of 2005 occupies that middle tier. It is a plenary statute designed by Parliament to maximize transparency across government operations. The 2011 state notification sits squarely on the bottom tier. It is a piece of delegated legislation attempting to carve out an opaque exception, pushing upward against the boundaries set by the RTI Act above it. The state's core argument relies entirely on this bottom-tier notification, claiming it provides an unassailable legal shield preventing the special police establishment from having to comply with the RTI Act. When courts review these claims, they apply a strict test. They check whether the subordinate legislation exceeds the specific authority granted by its parent act. The outcome of this case dictates whether states can weaponize delegated rulemaking to write their own exit tickets out of federal transparency requirements. When the case reached the Supreme Court, the state of Madhya Pradesh pivoted to a strict procedural defense. They pointed out a glaring gap. In his original writ petition to the High Court, Kamta Prasad Mishra never actually asked the court to strike down or invalidate the 2011 notification. This page from the judgment cites the Supreme Court's own binding precedent in Union of India versus Manjurani Routray. That ruling clearly states that before any provision of law or rule can be declared ultra-virus, there must be specific pleadings raising a formal challenge. The rationale behind this rule is straightforward: due process. If a rule is going to be struck down, the opposing party must be given a fair opportunity to justify its validity in court. Ordinarily, this lack of specific pleadings stops an appellate challenge instantly. The court cannot strike down a law no one formally asked it to review, setting the stage for an extraordinary judicial intervention. To bypass this procedural dead end, the Supreme Court utilized its suo motu jurisdiction. This is a reserve power held by constitutional courts to correct manifest legal errors. This is paragraph 33 from the Bihar Rajya Dafadar case, which the court referenced to justify this move. It outlines the plenary power resident in constitutional courts to guard against egregious violations, even without a formal petition. The court applied the standard from Bharathi Dasan University, establishing that courts must ignore regulations made outside their statutory authority. Crucially, the absence of a specific prayer to strike down a rule cannot confer legal sanctity on a regulation lacking authority. There is, however, one mandatory condition required to exercise this suo motu power. The court must grant the state full opportunity to defend the legislation in question. Following this rule, the Supreme Court explicitly halted proceedings and ordered the Advocate General of Madhya Pradesh to present a defense. The state used this opportunity to argue that the 2011 notification was justified under state legislative competence and the principle of institutional parity, claiming their domestic investigative agency deserved the same shield as national intelligence units. By granting this hearing, the court confirmed procedural barriers cannot protect subordinate legislation from judicial review, provided the rule violates the boundaries of the Parent Act and due process has been thoroughly afforded. With the procedural hurdle cleared, the court moved to the substantive statutory test demanded by the Right to Information Act. Section 24, subsection 4, lays down a strict dual-pronged condition. Exemption from transparency requirements is exclusively reserved for organizations dealing in both intelligence and security. To determine what the legislature actually meant by those terms, the court examined the agencies already listed in the RTI Act's second schedule to serve as benchmarks. First, they looked at the Central Reserve Police Force. This is a baseline statutory example of a dedicated internal security force. Next is the Border Security Force, an armed organization explicitly dedicated to ensuring the sovereignty and physical security of India's borders. Finally, they analyzed the National Investigation Agency, a specialized unit formed to investigate and prosecute offenses directly affecting the core integrity of the nation. The court contrasted these robust national security benchmarks against the special police establishment. The SPE has a specific, limited statutory mandate, investigating economic offenses and corruption under the Penal Code. Investigating anti-corruption and economic malfeasance falls entirely outside the strict statutory threshold of intelligence and security. This renders the state's classification of the SPE legally incoherent. We can now evaluate the 2011 state notification based on this comparative analysis. The state attempted to expand the definition of exempt organizations to hide the special police establishment. But a delegated rule cannot stretch beyond the language of the law that enables it. Because the 2011 notification exceeds the explicit authority of its parent statute, the Supreme Court declared it ultra vires, rendering it entirely invalid. The state's secondary defense under Section 81H collapsed as well. Since the investigation was complete and the charge sheet filed, providing the documents posed no risk of impeding the judicial process. The court successfully utilized its plenary sua motu power to enforce strict statutory boundaries, refusing to let procedural imperfections shelter an invalid law. State governments cannot unilaterally shield domestic investigative units from the RTI Act using delegated legislation. Transparency remains the overriding statutory default, unless explicitly overwritten by Parliament.